Welcome to What the Risk? Exposing Business Blind Spots, an interview-based podcast series that discusses risk management topics. Have you ever been blindsided in a business situation? Think about your entire computer system going down, a supplier that cannot deliver, or your biggest customer declaring bankruptcy, or your new marketing strategy completely missing the mark. These are visceral what the risk moments. Your exact words may be different, but the feeling is the same. When everyone's eyes are focused on the next sale, high-impact, low-visibility risks often get overlooked. We call these blind spots, and these blind spots cause what the risk moments. I am your host, Larry Gordon of Gordon Risk Solutions. Join us on this journey as we learn to ask the right questions, expose potential pitfalls, and empower you to turn the what the risk moments into I've got this victories. Our guests today to talk about intellectual property are two lawyers from the Ulmer law firm. We have Rachael Rodman and Matt Schonauer. Matt is a practicing attorney focused on intellectual property preparation and prosecution of domestic and international patent applications. He serves as an advisor to pre-revenue and growth startups, and he practiced mechanical engineering before he became an attorney with experience in printed circuit boards, software development, and mechanical product design industries. He's also well published in intellectual property. Our second guest is Rachael Rodman. She's an IP litigator representing clients of all types of intellectual property litigation, including patent, trademark, copyright, trade secret claims in forums across the United States. She's recognized in the World Trademark Review, WTR 1000, as one of the world's leading trademark professionals. She's also named into the Ohio Super Lawyers list. We welcome both of them for a very informative session. Welcome.
Thank you.
Thank you.
So you both work in intellectual property, but you have very different roles in that. If you can talk a little bit about the different roles you have and describe what the differences are. Matt, let's start with you. What areas of IP kind of do you focus on? Do you have a specialty within that? And then I saw something about what you do for Amazon Marketplace. So if you can talk about that.
Yeah, sure. So I do focus on sort of procurement and management of IP assets at the formation stage and identification stage. I'm a registered patent attorney, so I can prosecute patents, but I also will register trademarks and copyrights, kind of the whole kit there when it comes to that. So I don't necessarily focus on one of those areas. I try to take a holistic approach. But that's probably the focus of what I do. I mean, I've done some enforcement, Rachael a lot more than I have. So I'm happy to have her now to lean on and get her expertise with my practice. And so procurement, identification of IP, and then you mentioned the Amazon Marketplace stuff. So I have several clients in the Amazon and other third-party marketplaces in general are pretty popular now. I mean, you've got Amazon and Alibaba are like the two big ones, but there's others. So there's a lot of independent sellers on there that have a lot of IP issues, whether it's somebody's selling a patented product of mine on those marketplaces, or somebody's knocking off my trademarks, or there's really a lot of issues that can come. And because it's a private marketplace, there are mechanisms in some of those marketplaces where you can try to enforce your rights, but really getting them in order first to be able to enforce them is really important, especially when it comes to like Amazon. They have a brand registry where if you don't have formal IP rights already, they really don't help you very much. They just kind of say, well, you're out of luck, and good luck with that. So,
well, very good.
Yeah.
So, Rachael, if you can tell us more about your litigation practice, and I'm looking forward to a lot of war stories through this whole session, and help us understand kind of if there's particular industries you focus on, kind of your level of practice. Is it mostly kind of the mediation pre-trial, trial, appellate?
Sure. So, as Matt said, I do IP enforcement. So that is overwhelmingly the biggest part litigation. and federal court litigation. And I litigate all types of IP, like we said, patents, trademarks, copyrights, trade dress, trade secrets, and any sort of nuance of those that you could fathom. Mostly in federal court, but also in a number of other forums, things like the Trademark Trial and Appeal Board, if somebody is filing an opposition to an issued trademark or a trademark application. The Patent Trial and Appeal Board for things like inter partes reviews to challenge patents, the ITC, which is the International Trademark Commission, which deals with preventing the import of at customs of anything really, but things violating intellectual property. Sometimes in state court, although that's rare for intellectual property. And then even things like Matt was talking about, some of the mechanisms for the online sellers like Amazon, you get involved in some of those. So any type of IP litigation in any forum, I handle. I also handle things like licensing, which is in the bucket really of enforcing IP, making sure that you're getting appropriate royalties for your IP, or if you need to license somebody else's IP, what does that relationship look like? And then the only time I really get involved in kind of pre-litigation planning is on the trade secret side, where I've done quite a number of audits of trade secrets and their protection for companies to ensure that if they find themselves in litigation, they're well set up for what that litigation might look like.
Well, very good. Very good. So as we get into the meat of this, I do want to make sure that we get to know you kind of professionally. Do you have any things that you've worked on recently or currently working on that excite you?
I'm always working on things that excite me. Matt and I just filed a case yesterday. That's a trade secret case. We can't talk about the details too much yet, but it's going to be a fun trade secret case, I think. I've got a patent case that's been ongoing for years, as patent cases often are, that's set for trial next year. So we're sort of in the final motion practice, getting ready for trial of that, which is exciting. We don't do very many trials in IP litigation anymore because it's so expensive. So whenever we get this far, that's always a lot of fun for me. I don't know how fun the clients find it, but I, as a litigator, that's why you hire me, because I find it fun.
Very good. And what are you working on, Matt?
So I have a variety of clients that are launching successful products, and it really to an international market. So right now, currently, I'm coordinating some pretty quick buildup of IP on a international level. So trying to coordinate with foreign associates. So we have other law firms in different countries that we work closely with, because all IP is really territorial in nature, and due to treaties between most of the industrialized countries in the world, you have to have IP rights in each location where you're going to be doing business. So I'm doing a lot of that right now, just kind of coordinating and being prepared so that we can stamp out knockoff counterfeit products before they flood the market, which is, once that starts happening, it gets more difficult. So being prepared for that kind of thing when you know what's going to happen really gives you a leg up. So I'm doing a lot of that right now.
Well, terrific. So as we talk about the risks and strategies of intellectual property, I want to make sure from a context perspective, our audience are going to be business owners, business leaders that want to understand how to protect and defend and kind of think about the asset that they have. And they're going to be in companies from retail to service, manufacturing, entertainment. We also have a lot of people that listen that are lenders or investors that want to understand what are the right questions to ask, because if they don't understand what they're being told, well, then that's bad on them. I want to make sure that they have the context to ask the right questions. So with that as context, let's do a quick level set, and it's probably more in your camp, Matt, the different types of intellectual property protections and what the process is for businesses.
Yeah. So as we kind of alluded to earlier, the four main types, there's kind of four buckets of IP, traditional IP. You've got patents, trademarks, copyrights, and trade secrets. So patents, there's three types of patents: utility, design, and plant. Most people think of utility patents when we talk about patents. They make up, 3/4 or more of probably all issued patents. Mm-hmm. A patent covers an article of manufacture, a process, a method of doing something, really a product or a way of of accomplishing something. It sort of protects the product and the idea behind the product. Um, the trademarks, on the other hand, they are source identifying protection kind of IP. So it kind of arose out of the common law and business torts, and saying that, hey, somebody shouldn't be able to come along and call their business the same thing as my business to trade off of the goodwill that I've built up in the marketplace. So those have their roots in use, but there's a registration system that gives you more rights, and you can kind of keep protection around your brand. So those really cover anything. Typically, we think of names or logos, but really, you can protect under trademark law anything that it operates to identify the source of goods or services. So that can include things like sound, like the NBC 3-tone jingle. That is a registered trademark. And then copyrights protect creative expression and the works of creative expression. So these things will typically cover things like literary works, motion pictures, music, sound recordings, architectural works, sculptural works, all those kind of things. Anything that there's some kind of expression being put into some end product that you can tangibly, see. And then trade secret protection is it's a legal framework that lets you try to keep the products, like the important things to your business, secret, and protect that from being kind of unauthorized exfiltration of things that are commercially valuable to your company. So if you take those kind of steps to protect it, and like Rachel said, she does a lot of that, so she can probably elaborate on that a little bit more. But those are the four main areas that we kind of look at first when we talk to a client.
So when a business owner is running and operating their company, how should they be thinking about looking at everything they do? Should they be kind of logging everything? Should they be figuring out, okay, do I have to sit down with my attorney to say, okay, what's protectable here? Or kind of how do I kind of file for this? How should a business owner think about kind of next steps?
So, I represent clients that kind of run the range of sophistication in their knowledge of what is IP and how can I identify it and how is it useful to my business. So depending on kind of where you are in the spectrum, I like to come in and say, look, the more that I know about your business and that I really understand your goals and what drives your revenue and where your